Jerry Agar for Ezra Levant. If a group of people are treated differently based on heritage or skin color, that's racism. When the government does it, that's institutional racism, a worse scenario than what people suffer from ordinary bigots. But what sort of decent nation passes laws demanding that one group be treated differently under the law? Not Canada, that's for sure. Well, actually, it is Canada. Tom Broadbeck of the Winnipeg Sun is here. Welcome, Tom.
Hi, Jerry. Thanks for having me.
Thanks for doing it. What we're talking about is the GladDo provision. Can you explain to us briefly what that is?
Basically, what it requires is that the courts give special consideration to Aboriginal offenders. Basically, they have to complete a GladDo report. GladDo is, by the way, is the name of a Supreme Court of Canada case dating back to 1999. The requirement is that when an Aboriginal offender comes before the courts, that there must be a GladDo report penned at sentencing, meaning the GladDo report has to lay out all of the backgrounds of the Aboriginal offender, has to talk about the historical wrongs like residential schools and displacement and other historical wrongdoing that are common for some Aboriginal people. And these reports have to be brought into the court at sentencing, and the court and the judge must consider this report when sentencing. And they've been instructed to look at some of these historical wrongdoings, as I mentioned, as mitigating factors. In other words, they could be used, they may be used by the judge to give the Aboriginal offender a more lenient sentence.
All right, because they've had a tough life because of these things, and many people may be watching right now and say, well, that's true. But if, however, your life was upset and you're in trouble in part because of fallout from how you were treated by the Khmer Rouge and now you live in Canada, too bad.
Too bad for you. Or if you've been affected directly or indirectly by, other human atrocities like the Holocaust. If you have other, realities with respect to your background that may have led you to a life of crime, those aren't automatically put into a report and given to the courts the way GladDo is.
All right. Now, you wrote about it, and then you heard from Rob Nicholson, the Justice Minister, and it seemed to me, we'll see how it looks to you, that he said some conflicting things. We're going to look at several things that he wrote to you. At a general level, Aboriginal offenders are subject to the same criminal justice laws and sentencing principles as all Canadians. Well, first of all, how do you respond to that part?
Well, that's factually incorrect, because you have a provision in the criminal code that's been interpreted by the courts to give special consideration to the circumstances of Aboriginal people based on their race. So that's what Rob Nicholson is saying there is factually incorrect.
All right, and then he goes...
That's fairly obvious. I mean, it doesn't require elaborate explanation.
No, I don't think that you have to have a legal degree to understand that if the thing is there and it applies only to a certain race, then obviously you've got a differentiation. And then he said, and this seems contradictory to what he first said, as a direction to judges to try to alleviate Aboriginal overrepresentation in the correctional system to the extent that this is possible. So if the idea is to have fewer Aboriginals in court and they're taking it up as a consideration to give you a lesser sentence, then his first statement was incorrect.
Yeah, I mean, and the principle behind this, that they're doing this to try to address the overrepresentation of Aboriginals in jails and in prisons. First of all, it hasn't worked. This has been on the books since 1995, and it hasn't worked. There's still an overrepresentation of Aboriginal people in our prisons. If they want to talk about doing something about that problem, they should be dealing with some of the root causes that are causing that number of Aboriginal people to end up in prisons. Giving lenient sentences based on somebody's race is not the way to do it. It hasn't worked. It's racism. It's discrimination, and it's in my view a Charter of Rights violation, which says that everybody before and under the law is equal, regardless of their race, their age, their sex, their economic circumstances.
Well, one more from Rob Nicholson. Generally, Aboriginal and non-Aboriginal offenders who commit violent and serious offences are likely to receive similar terms of imprisonment. Well, likely is kind of the word there, I think.
Yeah, I mean, that's a very well-crafted legal sentence, isn't it? I mean, generally, likely, similar, that may be true, but there are cases, and I've sat in courtrooms and I've listened to judges use the GladDo reports as a mitigating factor, where if that person was Filipino or Chinese, wouldn't have the same benefit of the law. when being sentenced by the court. So yeah, in many cases it could be that the outcome of the sentence is similar, but there are many cases where the judges use these GladDo reports and they use them as mitigating factors in sentencing.
All right, so it seems surprising to me, actually, that we get this from Rob Nicholson in the Harper government.
Yeah, it seems very surprising to me. I mean, here's a law and order government that you would think would look upon a law like this, which, by the way, isn't their law. As I said earlier, this was brought in 1995. It was brought in under then Liberal Justice Minister Alan Rock. And when it was brought in, there was very little discussion about it. A lot of people have never even heard of this law before. And so it wasn't brought in by the Tories, and you would think that kind of a law and order government like the Harper government would look at a law like this and at least examine it and decide whether it should still be on the books, because again, the way it's written in the criminal code is it's very general and ambiguous. It's been interpreted by the courts in its application today. It's very vague in the criminal code. It simply says that courts should pay special attention to the circumstances of Aboriginal people. The courts have then taken that, as they often do, and they've defined it and they've decided what it's going to be. I don't know why the current government wouldn't at least look at this law now in hindsight, many years later, and decide whether it's really fair and just to have this kind of a law. Yeah. You can still look at the background of Aboriginal people or any other person that comes from unfortunate circumstances when crafting a fit sentence.
Yes, but a law like this is racist. It's infantilizing, I think, of Native people, and it's un-Canadian. Thanks for your time.
Thanks, Jerry.